When parents can no longer live together in the same household with their child or children, they often need to turn to the court system for help in figuring out what the custody situation and what the parenting time schedule should look like. Hi, my name is Tracy Dominique Boyd. I'm an attorney with Lakeshore Legal Aid, and I've been practicing family law for 26 years. I'm here to explain to you the different factors that the court needs to consider when making a custody determination. When figuring out what party should have custody or what the custodial situation should look like moving forward, the court has to look at a number of different things. Those are called the best interest factors. Those are actually in Michigan law and they're listed out very specifically. So each parent, when they have their hearing, will need to present evidence on each of those factors so that the judge can make an informed decision about custody and parenting time. The first best interest factor that the judge needs to think about is the disposition of each parent to give love, affection to the minor child, and also the existing emotional ties that are between the child and each parent. Ways that you can prove to the judge what your position is on this particular factor are to talk about when the child gets hurt, who do they look to? Who's always there to comfort the child? Who helps the child with emotional support or spiritual development? The next factor that the court needs to examine is the capacity of each parent to provide support and guidance ongoing for the child as the child matures. Different ways you can prove to the court this factor include talking about who's primarily been responsible for bathing and dressing the child, getting them ready for the day while the parties were living together, if they have ever lived together. Another thing you can use to prove this factor would be which parent or parents primarily lead the child in their spiritual development, who takes responsibility for doing homework with the child after school, and which parent or parents are the disciplinary parent. If both parents are disciplinarians, what different types of discipline are used by each parent, if that varies? The third best interest factor that the judge needs to think about is the capacity of each parent to provide for the child. Now, this doesn't mean that the parent with the most money or the highest income automatically gets custody. It's actually the exact opposite. What the court will look at is what is the capacity of each parent to provide a stable house, clean clothes, food, and to get necessary medical care expediently when the child is injured. Fourth, the court needs to consider the stability or the length of time that the minor child and each parent has lived in their current home environment. If you've moved recently, be prepared to explain to the court why. The court will not only look at the stability of each parent's current housing, but will also go back and look at how the housing has changed or has been affected throughout the life of the minor child. Then the court will expand its focus and look to see the stability of the surrounding home environment for the minor child in each parent's household. To do that, you should be prepared to talk to the judge about your extended family members, such as grandparents, aunts, uncles, siblings that might be present and might help raise or care for the child if the child is in your custody. Next, the court is going to consider the moral fitness of each parent when they're doing this analysis. Now, what's important to recognize is that the definition of morality is a continuum. So just because a person has a certain occupation or title does not automatically mean that they're more morally fit than the opposite parent. Next, the court is going to need to know that both parents are mentally and physically capable of caring for the minor child. So things that you can use to prove this factor are to talk about your mental health and your physical health, not just currently, but also the history. Same for the opposite parent. But please keep in mind that any factor that is brought forth under the best interest factor number 7, when you talk about mental or physical health, you need to tie it back to the ability to parent. The fact that a person is in therapy, for example, does not automatically make them a bad parent in the eyes of the court. Factor 8. The court needs to look at the home, school, and community record of the child. To help the court understand this factor, things that you should introduce to the court include: what is the academic history of the child? Has the child stayed in the same school consistently or changed schools often? How are their grades? Are they tardy a lot? Do they miss a lot of school? Another thing to help prove to the court which home or homes should be the primary custodial home for the child would be: where do the child's friends live? And if the child is living with the opposite parent, will they still have the same opportunity to visit with and spend quality time with their friends? Another factor the court will consider is the preference of the minor child if the child is sufficiently old enough. Please keep in mind that the preference of the child is not the be-all, end-all of the court's decision. The court will listen to what the child has to say, but it will not tell either parent, to create a safe space so that the child feels free to share with the court any information the child wants the judge to think about before making the custody decision. The next factor is the willingness and ability of each parent to facilitate parenting time and cooperate with the opposite parent. The goal of the court here is to ensure that both parents take an active role in raising their child together. Sometimes that's not safe, and so that's why facts need to be presented to the judge on this factor, such as whether or not one parent talks badly about the opposite parent to the children, whether or not one parent has withheld parenting time from the opposite parent, or if one or both parents have used the minor children as a messenger or go-between, which is always inappropriate. Perhaps most importantly, the court needs to consider whether or not there's a history of domestic violence, both within the relationship of the two parents, but also with the relationship that each parent has had outside of their relationship with each other. When presenting this factor to the court, you might consider talking about criminal history, you might consider talking about actual events and specific dates and times where violent acts have occurred. Please keep in mind that domestic violence does not only include physical violence, but includes emotional manipulation, financial coercion, and isolation as well. The court also needs to know whether or not the minor child has witnessed or overheard any of the violent acts between the parents before they make a custody decision. And finally, the judge will consider any other factor that either parent thinks is relevant and wants the judge to know about before they make their final custody decision. I hope you found this video informational. If you have questions, or if you'd like to see if you're eligible for legal assistance, please reach out to us at Lakeshore Legal Aid at 888-783-8190, or go to michiganlegalhelp.com on the internet. There's a list of frequently asked questions that might be helpful to you, but also that website can help you fill out court forms that you may need to file with the court related to your custody situation.